Hello, Garrett. It's so nice to see you again.
Hi, Rhonda. Thanks so much for having me.
Well, I always enjoy our conversations together, even though sometimes the topic is pretty grim. This time, our topic is freedom of the press. And so I'm so happy to have you on. I want to start off with the constitutional guarantees and what exactly the Constitution has to say to protect our independent press.
I'm a big believer, and let's read what it actually says and go from there. So, radical idea back in the late 1700s about having free speech in a national constitution. The framers, right first thing in the Bill of Rights, said Congress shall make no law abridging the freedom of speech or of the press. Um, Radical for its time. No censorship, no having to get a license from the government before owning a printing press and publishing your own newspapers.
And I find it interesting that they group the freedom of the press with freedom of religion, freedom of speech, and the right to peaceably assemble.
Well, it made sense in the time, and I think it makes sense now. What was different about the nation in the 1700s than the nations of Europe was that our country had many different religions, right? Mostly Christian, but different sects of Christianity. At that time, they were afraid of the government taking over their religions. And so all these things, free speech, free press, free religion, the right to assemble, the right to petition, they all were in the same kind of nexus about how do you have a free society? How can you have a society filled with liberty in all these different ways?
Why do you think that the founders did not include these freedoms within the Constitution itself, and rather they were part of an amendment that came shortly after the Constitution was ratified? Did something happen that they felt like they needed to add on to the Constitution to guarantee these freedoms?
So the short answer is yes. I'm someone who views the Constitution as miraculous for its time in how well it was structured. But we have to remember the Constitution was only written in about 3 months,
Mm.
right? Like a very short time period of the Constitutional Convention convening secretly, basically, in Philadelphia behind closed doors and drafting the whole thing. And as brilliant as it was, there still needed to be a public debate process for that final product. One of the small intricacies about the framers in the convention was many of them viewed the federal government as needing to be incredibly small. They looked for state governments to be much bigger in many ways than the federal government. So they didn't see the need to include Congress shall make no law abridging the freedom of speech because they didn't think they were giving Congress the power to abridge speech. They didn't think they needed to prohibit Congress from establishing a national religion because they didn't think they were giving Congress the power to establish a national religion. Many of them thought that way. It really would not have occurred to many of them to have that kind of affirmative right guarantees in the Constitution because they were trying to limit the future Congress and president in so many different ways. That being said, many of the state constitutions at the time had firm guarantees and Bill of Rights. So there was a tension in the convention itself about whether to include a Bill of Rights or not. Ultimately, it was outvoted in that moment. But in order to have the Constitution ratified by a vote of the people in the next 2 years, that had to be revisited. And it had to be made clear we need certain guarantees in the federal Constitution. They need to be spelled out just in case. Having the right to free speech, the right to a free press is necessary in order to have a free democratic government. It's not sufficient. It's not enough that we have a free government, but it's vital that we do that. Having free speech and a free press ensures that when abuse of the government is uncovered or powerful figures, it can be reported on. It can be discussed by the public. That ensures that the electorate can be informed. They're not always going to be, but they could be. That's important. It limits the ability of the government to operate in secret. That's very important. There are times, of course, when a government needs to meet behind closed doors, but for the vast majority of what a government does, it needs to be viewed and checked by the public as a whole. People in power, I think many of us have come to realize they don't fear the law, they fear the spotlight.
Let's get into the New York Times versus Sullivan case, because that was a big one in 1964. It really did set the precedent for this idea of intentional malice connected to journalists and their reporting of events. So, explain that case to us, if you will, Garrett, and how it is so important in terms of protecting freedom of the press.
So the New York Times versus Sullivan is one of those cornerstone cases in the constitutional law canon. It's foundational to how we view free speech and a free press. So what happened in 1964, remember, middle of the civil rights movement, is that an ad was taken out in the New York Times criticizing the police in Montgomery, Alabama. It advocated for less police brutality. It advocated for Dr. King and many civil rights leaders. But that ad also did contain some inaccuracies. One of those inaccuracies is that it had said that Dr. King had been arrested 7 times by the police there. Actually, only been arrested 4 times, right? So these little small things. Another one was it criticized the police in Montgomery, Alabama for ringing around the university. They hadn't physically surrounded the entire university. They were just nearby. But that was enough for the police chief in Montgomery, Alabama, to send the New York Times a demand letter that they retract the advertisement, that they retract the criticism of his government department. And he felt that because he was in charge of the department, the New York Times was pointing its criticism and its lies directly at him.
So, this was a commissioner, and his name was Sullivan. And
Yep.
he was upset with the New York Times for this ad because he thought that they were personally defaming him in some way.
That's what he felt. You can see how tangential that gets, right? Because they weren't naming a specific person. This is a government entity. Sure, he's in charge of the government entity, but it's many steps away from even criticizing him directly.
And we could probably say that what he was most upset about was that the New York Times was highlighting the racial discrimination in the South at that time.
Exactly.
He didn't like being in the spotlight.
Exactly. They were shining the spotlight right on his department, and he did not like that. At the time, Alabama libel law required that he send a demand letter first to the person or entity that had published the supposed lies,
Cease and desist.
a cease and desist letter saying, you better retract this.
Okay.
Concurrently, the governor of Alabama did the same thing because he felt that Alabama was being unfairly criticized and he was head of Alabama.
Okay.
So,
And what did the New York Times do? They didn't back down, right?
well, for Alabama, they did. They published a retraction as it concerned Alabama. I don't know if they would do the same thing today. I think many media outlets today would not do that, but they did for Alabama specifically. For Police Chief Sullivan, they did not publish a retraction.
I see. Okay.
They did send him a letter that said, why do you feel like we are criticizing you specifically? Why do you feel that we are maliciously going after you? And he declined to respond to that letter. And instead, he filed a libel lawsuit for defamation against the New York Times.
And didn't he win that suit in state courts?
Of course, Alabama civil rights movement times, absolutely. And so you can imagine it goes up to the Supreme Court. And what really was at issue in this case was, can a person or an entity publish or make criticisms against a public official or a part of the government, even if that might contain some inaccuracies. That's a big thing because it could be that a reporter publishes a breaking news story about government corruption, but there's a kernel of something that's just not right because they're having to scrape so many different sources together. So if the Supreme Court had said, no, you cannot publish anything with any inaccuracies, that would chill free speech.
Oh, absolutely. Because there's always the possibility of getting some of the facts wrong. I think most journalists are very conscientious about trying to get the facts straight. But when there's a lot of conflicting information out there on a complex topic, there's possibility of being wrong. So yeah, I think that would be a huge chilling factor to say, oh, you can never get anything wrong. People wouldn't write anything.
Especially independent journalists on the ground in states or even in DC. How could they possibly publish anything without fearing that they were going to be sued and hauled into court on any number of issues all the time?
Mhm.
It would gut the First Amendment. When it reached the Supreme Court, Justice Brennan delivered the unanimous opinion of the court that said public officials cannot win defamation suits unless they show that the publisher, the person who made the statements and the lies, uh, made those lies with actual malice. They needed to have known that the statement was false and they were acting with reckless disregard for the truth. That's a very high bar.
Yes, it is.
As an attorney, I would have to go into court. I'd have to go to a jury. And not only would I have to prove the thing is wrong that was said or published, I'd have to prove the mental state of the person or the publishing company who said it. That's incredibly difficult to pry open someone's brain to say, look how mean and malicious they want it to be.
Yeah. At that time, wasn't there a more liberal Supreme Court in place? And that ruling really reflected a more liberal stance about freedom of the press. Uh,
It was the golden age for many of our cornerstone constitutional principles. It was the golden age for having a constitution framed in liberty.
Now, subsequent to that ruling, I'm sure there have been numerous court cases that have invoked the New York Times versus Sullivan precedent. Can you talk a little bit about some of those?
One of the important ones is the Barnick v. Vopper case. That was in 2001. So relatively recent in our timeline. It was delivered by Justice Stevens in a split court, as the court often is nowadays. But in that case, a radio commentator aired a phone call that had been illegally recorded by someone else. You can imagine a scenario where someone is illegally or secretly recording a political conversation, a conversation between a union leader and someone else. And with that, they want to run to the press and say, look what happened. And so the question was, can the press publish that? They didn't do anything illegal. They didn't secretly record anyone in violation of the law, but these facts had been presented to them. The question was, can the press publish truthful information of public concern, even if it had been illegally obtained by a third party? This is another cornerstone case in what can the press do under the umbrella of the First Amendment? And ultimately, the Supreme Court affirmed that they had the right to publish leaked materials. Even though it had been illegally obtained, it was wrong, whoever did it could have gone to jail. The press, once they had that information, could not be prohibited from publishing it. That was critical precedent concerning the WikiLeaks files or the Snowden cases.
Oh, wow. That is an important ruling, and it could really have a lot of impact on things where you're leaking information from a government that's not being very transparent.
Absolutely. You can imagine the White House issues a rule for the entire staff. They probably already have. You cannot disseminate information you learn in the White House. And a White House aide learns of some massive corruption scandal. And they want to run to the nearest reporter and say, you need to tell the public that this kind of embezzlement or fraud or something horrible is going on. Had this case not come down, the members of the press would have had to have engaged in analysis of, am I going to be violating the law by publishing this critical information for the public? That would have a major chilling effect on the press. That would have a major chilling effect on democracy because voters would not be able to get the information they needed except through official channels, which can be compromised.
I want to go back to the New York Times versus Sullivan case because we have a more conservative Supreme Court now. Clarence Thomas, in a dissenting opinion, laid it out that he would like the court to revisit the New York Times versus Sullivan ruling because he certainly is very antagonistic toward a free press.
The Supreme Court could revisit it at any time they want. It's not surprising that Justice Thomas wants to undo key cornerstone constitutional rulings for free press. The press has criticized Justice Thomas many times over the decades for his actions, personal relationships, massive gifts he has received from wealthy billionaires. They've criticized his rulings, given how they seem to lack principles or any kind of basis in constitutional law. So it's not surprising that he wants to undo those protections for the Constitution. For Justice Thomas and Justice Alito are definitely pushing the court as much as possible to revisit practically every major case from the last century to come up with new rulings. The court is not supposed to be doing that. The court is supposed to build case law on top of each other, understanding precedent, and very rarely, only in emergency circumstances, undoing a prior case.
It seems like this conservative Supreme Court is working hard to undo the laws, the precedents that were set during that time period of the civil rights period and all of the court cases that came before them and that we have enjoyed for decades since then.
Yes, there's a concerted effort to dismantle all the cases from the civil rights era. I mean, we saw the deconstruction of the Voting Rights Act under the Roberts Court. We've seen all kinds of cases aimed at doing that. We hear from politicians that they want to undo gay marriage, which is far more recent, but they want to undo laws that protect interracial marriage and things of that nature. When you zoom out to 1,000 feet and you look back down, it's quite shocking. When you're in the moment, you might not see it as well.
Right. And I think that's a really good way to put it. Since it's the case that federal protections for press freedoms are becoming weaker, it seems that state level protections are becoming even more important than they have been in the past. I want to talk to you about these anti-SLAPP law at the state level, what they are and how they provide safeguards for an independent press.
I think it's important to set the table for this a little bit, that every single state constitution has a parallel free speech and free press guarantee somewhere in there. They have it in their Bill of Rights. Oregon's constitution has that. It's Article 1, Section 8. Many of these provisions nationwide have the same language as the federal constitution. It would say the state of X shall make no law abridging the freedom of speech or of the press. Oregon's constitution is slightly different because it uses different language. And it says that, everyone may speak or print freely on any subject, which is broader language than the federal constitution. It's broader language than the federal Bill of Rights. That's important because that means that in Oregon, you have more free speech rights here than in many other states. It's also important because there is a doctrine in the United States that basically says when a state constitution or a state law parallels the federal constitution or federal statutes, like they use the same language, the Supreme Court could interpret those provisions as state law itself. And they could make cases defining what that state law or state constitution says. That is concerning because you could have the federal Supreme Court basically saying what the state law is. That's not normal. What we have in Oregon is because we had used different terms, we use different words, the federal Supreme Court can't go and make an interpretation of our Constitution. That is left up to the Supreme Court of Oregon itself.
That is an excellent point, Garrett, that I don't think most people know about. I certainly did not.
One of those intricate safeguards built into our system is that if you use different language, it can be interpreted differently. Normally, a state Supreme Court gets to interpret their laws and their constitution apart from anyone else. They're the final decision maker. And it's only when you're using the same laws or the same terms, the same words, that it becomes an issue. So as we're going forward and trying to build state protections over the coming years and decades, it's going to be important for the legislatures to use different terms when they're coming up with laws and constitutional amendments locally. So that kind of sets the stage about one part of this. The other part about this is that the United States does have a distinct history concerning defamation litigation than England. Most of our laws come somewhere in the past from English common law. If someone was lying about you, you hauled them into court. And if you're a rich person and you want to hassle someone who's saying not nice things about you, you haul them into court. Going into court obviously can be very expensive for everyone involved. But if you're rich, that might not affect you as much as a working class reporter or some middle class person who wants to get the word out about something. So what had been happening over time, but especially in the late 1900s, is that powerful people, rich people, were strategically suing members of the press and members of the public who were saying bad things about them. Oftentimes, bad things that were true about them. They realized that it would cost them little to haul these people into court, but the reporters and the people they were hauling into court, it would cost them everything. Even if those reporters ultimately won. Attorneys are expensive. To successfully defend a case, it could cost $100,000.
Right.
Right?
And these kinds of frivolous cases have been called strategic litigation against public participation, right?
Yes.
That's
Yes.
the SLAPP part.
So they would strategically litigate against those in the public realm, those who are trying to engage the public with facts. And big problem, right? Because if people are hauling reporters in because they don't like the stories they're publishing, major chilling of free speech. So many states started passing these anti-SLAPP laws to ensure that we can't prevent someone from suing you. You need to be able to go to a court clerk and file a lawsuit, but it will make it much quicker and cheaper to dismiss that case. That was really the goal. And so in Oregon, we have an anti-SLAPP statute. It's in Oregon Revised Statutes, Chapter 31.
I understand it's a strong one.
It's incredibly strong, especially because if you're the reporter being sued, if you're the whistleblower being sued, and you get the case dismissed, you get your attorney fees. And that's very powerful because not only are you out $0, but the other side has to pay their attorneys, and then they have to pay you as well.
That serves as a pretty good deterrent, I think.
Yes, it does. There's nothing I like better as an attorney than finding out I might get my client attorney's fees. It's a big win.
Mhm.
So you can imagine litigation. You just see attorneys going straight to trial. They get in front of a jury and a judge. For a litigator, for an attorney, that is eons away. It's a marathon. They have all these different steps they have to complete before they can get in front of a jury. One of the first steps, you file your complaint, you get it served on the other party, and then the other party gets to file a motion to dismiss the complaint for some reason. or they have to file an answer to that complaint, right? So that's a multi-step process. And for the responding party, being able to file a motion to dismiss the case before you have to file an answer, that's the goal. Being able to say, there's a legal defect in this complaint. And so what the anti-SLAPP law does is it allows the responding party to file a special motion almost day one in the lawsuit to get it dismissed, to get it kicked out of court before anything even begins. And so that was really the goal of Oregon's anti-SLAPP law. Get rid of these lawsuits that target reporters and then award fees and damages to the reporters who'd been sued.
Have they been successful?
Yes, I think so. When lawsuits occur against reporters, when I see them pop up in Oregon, it takes a little bit of time because you have to still get in front of a judge to argue the motion to dismiss. But almost always those lawsuits are being dismissed, or at least those relevant portions of the lawsuits are being dismissed.
So, Garrett, I hear you saying that here in Oregon, at least, we do have pretty strong protections for the press.
Yes.
That's excellent news. Let's go back to the federal level, and I want you to summarize some of the most important steps that Trump has taken to limit freedom of the press, other than the fact that it seems like his favorite term is fake news. He's constantly talking about that, which I think is a really big deal. Just the constant barrage of rhetoric about fake news and bias. But other than that, what are some steps that he's taken to limit freedom of the press during this second term?
Well, we've talked a lot about executive orders before. What his administration is doing to dismember the First Amendment, to block a free press, is a little more complex than just bare executive orders. The first thing has been to ban critical outlets from White House press briefings. That has been one of the first things he did. We did that in 2018, trying to get CNN banned from the White House. It was temporarily blocked by a court, right? So he's doing a little more subtly this time and pushing press further away. They might still be allowed on White House grounds, but they're not allowed close to him to ask questions, which is a stark departure from presidents of the past who would stand up and answer questions from a critical media.
Hasn't he actually said, "Where are you from?" asking a reporter, and then when they tell them that they're from some outlet that he doesn't like, he won't answer the question. He'll just move on to the next reporter.
I do wish the members of the press would back each other up more. I wish they'd call that out more, but that's exactly what's happening. That's a little more subtle. People don't see that every day in their face, but that's happening. Big one, of course, is the defunding of public broadcasting, targeting PBS, for example, trying to defund Sesame Street because they, more often than not, don't have a political bias. They're just reporting the news.
Isn't that what he's saying? That PBS and NPR should be defunded because they are biased?
Exactly. If you're not reporting my truth, you must be biased against me.
Fake news.
Fake news. And he has, of course, a majority of Congress on board with that. This is an institution that has been built up over the last half century. It's an American institution and it's being deconstructed. So, that's another angle about this. Of course, there's visa restrictions on foreign journalists. We all expected that, targeting foreign journalists and trying to get their visas revoked or just straight out denied. Many of us fear that there's surveillance going on journalists. If it was reported tomorrow that there was illegal wiretaps or something of that nature on journalists, I don't think any of us would be surprised. It's that kind of environment right now in Washington, D.C. Highly antagonistic. If you're not speaking my party line, you must be doing something illegal. You must be corrupt. To me, the worst thing that's come out of the last 8 months of the Trump administration has been how certain major media outlets, ABC News, CBS, Meta, have kowtowed to the Trump administration. Trump filed a range of lawsuits against all kinds of press institutions for various things. Meta had banned some accounts, and Trump sued them for that. There was an interview with Kamala Harris, and Trump alleged that CBS News had engaged in deception regarding his electoral prospects. George Stephanopoulos had described Trump as being found liable for rape and not sexual abuse. And he sued all these kind of lawsuits like he normally does. Did any of these lawsuits hold water? I didn't examine them intricately, but from the facial looking at it, no, they didn't hold water. And yet, every single one of these press institutions in the last few months wanted to settle. Here, ABC News decided they wanted to give, what, $16 million to Donald Trump? CBS decided, we'll give $16 million to Donald Trump to settle this. Meta decided to give him $25 million to settle these lawsuits they probably would have won.
Why? Why have they done that? They basically agreed with Trump that, to me, it just seems like they are saying, oh, we know we've done something wrong. Let's try to settle this, instead of being strong about their press rights.
It's shocking. And it doesn't make any sense. It doesn't make any sense because this could prevent them from engaging in public participation or press activity in the future. A future president could say, I'm going to sue you, hand over some money. I'd like $25 million for my reelection campaign. Do they fear the federal government? These are very powerful institutions. They could change the minds of many voters. So why are they doing it? It could be because their boards of directors, their CEOs know Donald Trump personally. They know his advisors personally. They all run in the same circles. So it could be any number of things.
Do you feel like some of this is because the press, they're all run by corporate elites, that they are the very same oligarchs that are controlling our federal government now?
They all run in the same circles. When you have a press, I think about the 1800s, and every single small town had multiple newspapers, right? Multiple press outlets. And then you go to today, and the nation as a whole has half a dozen major press institutions,
Right.
while all the local media is wilting before our eyes. And so all of a sudden, we have virtually a monopoly on public information. And so how could they not run in the same circles? When there's only half a dozen CEOs of the press nationwide, how could they not run into major elected officials in Washington, D.C.?
Yeah. So what can ordinary folks like me and you do to support freedom of the press in our environment today?
I think, number one, continue to engage and exercise your free speech rights. As long as we're exercising our free speech rights, no matter what happens, they're still going to exist in some form. That's like step number one. Make your voice heard, be loud, do it as often as you can. You don't have to do it every day, but this needs to be an important part of your life. Number two, financially support nonprofit press institutions as much as possible. Growing up in the Rogue Valley, I'd listen to Jefferson Public Radio, JPR, and it's important to fund those institutions. Are you engaging with your local media? Are you reading your local news websites? Do you have subscriptions to those papers? They're often pretty cheap. So those are really important things. I think the state of Oregon needs to do a better job when it comes to ensuring that our state and local press has an easier ecosphere to survive in. Running a paper is not a lucrative business anymore. So whatever the legislature can do to find money to give grants or tax breaks to those institutions, the better, because that will ensure their long-term survival. We as the public need to ask our legislators to come up with laws that support those institutions.
Right.
We need to press for those.
It seems to me that the local press is going to become ever more important the more we realize that we can't trust information coming out of the federal government. We need to be able to trust our local media.
Absolutely. Locally, you can see some of the traditionally local news stations gobbled up by large conglomerates. But in the Rogue Valley in Southern Oregon, we still have independent journalists who are going around and reporting on stories. I know some of them, and I want to hear the stories they're reporting, whether it's local, whether it's state, whether it's national. Hearing from them gives me more confidence that what they're reporting is true.
Because you know who those people are. You see them around town.
And I know they're not going around with oligarchs and billionaires because I know them.
So, Garrett, what else do you think need to know about this very important topic right now?
There are times when free speech in our society expands, and there are times when it contracts. We are in a contraction age. Our goal and a mission, just like those who came before us and lived in parallel ages, is to ensure that this contraction is short-lived, to ensure that the contraction means that free speech doesn't disappear entirely, and to continue to push the edges and to advocate for free speech to expand again. That means ensuring that people have free speech, even if we disagree with them. That ensures having a free press that is able to publish things so long as it is not malicious against someone else. But also on the same scale, to press our press to have journalistic ethics, because there are many institutions out there. There are many people out there who are claiming to be reporters who do not engage with any kind of ethical guidelines. They're making up things, distorting the truth. It's hard, right? We're living in an age where many reporters are trying to convey these very important stories to the public at large. They have these alternate people who are trying to push these lies, this deception. And it's hard for regular people to sort out what's going on. To recognize that and to just try to be the most reasonable person and to look at these stories with a critical eye and a reasoned look, that's what's important.
And I want to add on to that because I've heard people in town say, "Oh, I don't read the local newspaper because I don't like it. I don't like what they write." And it seems to me that that's so wrong-headed. You can still support local journalism by writing to the editor, letting the people in the local media know what you don't like, and trying to make changes rather than giving up on it altogether.
Absolutely. Growing up, my parents got the Medford Mail Tribune every morning, and that was the first thing they did in the morning. They'd read it with their coffee, and that made it so I read it too as I was growing up. And my favorite section was always the opinion section. I wanted to hear what people's opinions were because oftentimes I thought they were wrong, but I enjoyed reading them nonetheless. There aren't as many letters to the editor in the Rogue Valley Times as I grew up with. There aren't as many people going to city councils and giving their opinion as it felt like when I was growing up.
Mhm.
I was on the Medford City Council. We had city council last night. We had several people come up during the public comment period to give public comment. It was the most amount of people we'd had in 9 months.
Oh, wow. And was there a theme?
Oh, yes. I was on the new $3 charge for utility bills going out by
Gotcha.
mail.
Okay.
Which I want to hear. I want to hear how the decisions we make as a counselor are impacting people. But it was nice that we got this kind of public comment because I feel I don't receive it all that much through these channels anymore. As far as I'm aware, they're not writing letters to the editor as much as they used to. They're not reaching out to their local governments as much as possible. Oftentimes, they're putting comments on social media
Mhm.
on news stories, which has its place. But there is that kind of engagement directly with either the public at large through letters to the editor or directly with your elected officials. Send them emails, put in public comments, make a public comment at a public meeting. Those are critical.
Supporting your local media, participating by writing letters to the editor, all important to ensure we have an independent press.
And because so few people are doing those things, you will have an outspoken voice. The elected officials will hear what you have to say when you do those things.
That's a very good point. Thank you, Garrett. This is a very important and complicated topic, and I appreciate you helping us break it all down. And thank you for joining me on this episode of ORD2 Indivisible's video podcast, Rogue Resistance. Please support this all volunteer effort by subscribing, giving us a thumbs up, posting a comment, and sharing the link with others on your social media. Until next time, stay informed, stay engaged, and stay indivisible.